But for right now, let's focus on getting the basics of it down. And as I said in our last lecture, the employment at will doctrine does not apply to cases of illegal discrimination. And in our case, Title VII of the Civil Rights Act of 1964 governs illegal discrimination in employment. Now, Title VII grew out of the civil rights movement of the 1960s, and therefore, although it primarily concerned race, it was also expanded later to include other protected classes. And Title VII requires equal treatment in employment without regard to membership in the protected class. So employers can discriminate, but only for legal reasons. They can discriminate on the basis of education. They could discriminate on the basis of experience, but they cannot discriminate on things like race or color or sex or national origin or religion. So understanding Title VII is vital for all managers, and again, you see it in the news all the time. And so therefore, this is a topic that's a very hot topic right now. So what does Title VII do? Title VII protects against employment discrimination on the basis of membership in protected classes. Now, what are those classes? 5 of them are protected in Title VII. Title VII protects individuals against employment discrimination on the basis of race and color. And again, this is what Title VII was originally about. However, when it was enacted, it also included protections based on national origin, on sex, and on religion. Now, what does Title VII say? Title VII says, "It shall be an unlawful employment practice for an employer to fail or refuse to hire or discharge any individual or otherwise to discriminate against an individual because of that individual's race, color, religion, sex, or national origin." Therefore, Title VII takes discrimination on these bases out of the employment at will doctrine. It specifically makes discrimination based on membership in one of these protected classes illegal, and therefore not subject to the employment at will doctrine. Now, Title VII has several protections built into it, and they include the following. First, employment requirements have to be uniformly and consistently applied. Furthermore, Title VII prohibits offensive conduct that alters the conditions of employment. This is why harassment is a form of discrimination. And finally, Title VII prohibits discrimination in compensation, and it prohibits physical segregation based on protective class. Title VII, as we mentioned previously, also protects employees on the basis of retaliation. So if you file a complaint, or if you cooperate in a proceeding brought by someone else, you are protected from retaliation by your employer. An employer cannot retaliate against an employee for taking advantage of their statutory rights. Now, Title VII permits an employee to sue in court for illegal discrimination. And there are 2 different theories on which an employee can base a claim of illegal discrimination. The first of these is what we call disparate treatment. Disparate treatment involves a policy or an action that is discriminatory on its face, meaning that is intentional. We are treating 2 similarly situated individuals differently. If I am the owner of a retail establishment and I have 2 employees who come to work, 1 man and 1 woman, and I fire the man for being late and I don't fire the woman for being late, then that is a case of disparate treatment. It's discriminatory on its face. It's intentional. Disparate impact involves policies that are neutral on their face but have a negative impact on a protected class. Let's start with disparate treatment. Talk about disparate treatment. Disparate treatment is used for cases of discrimination against an individual rather than a group. So to spot the difference between these two, first of all, look to see who's been discriminated against. An individual or someone who belongs to a similar group. Now, in order to establish a claim of illegal discrimination, the plaintiff has to prove what's called a prima facie case. And the prima facie case is an initial hurdle that a plaintiff has to prove in order to shift the burden of proof to the defendant employer. Now, the prima facie case gives rise to a presumption of unlawful discrimination, which is to say, if an employee can prove the prima facie case, then it is presumed that illegal discrimination has occurred. Therefore, the defendant must prove that it did not discriminate. Now, this burden switching device is very different from any other type of the law. Ordinarily, the plaintiff has the burden of proof at the start of trial, all the way through trial, and when it concludes. The plaintiff always bears the burden of proof. But in discrimination cases, the plaintiff only has to make an initial showing, called the prima facie case, in order to shift the burden to the defendant to prove that it did not illegally discriminate. Now, what is this prima facie case? Well, there are 4 elements to a prima facie case, and quite frankly, they're not hard to meet. This is on purpose. We want to encourage people to file their discrimination claims and then have the burden shift to the employer to prove that it did not discriminate. So the first thing that the plaintiff has to prove is membership in a protected class. So if you are going to bring a claim for sex discrimination, you're going to have to prove that you belong to that protected class. You have to apply for a job. You have to qualify for the job. And by the way, qualified in discrimination terms is different than what you might think. It's not best qualified or overqualified. It means that you meet the minimum standards for the job. So if the job requires a high school diploma, you have a high school diploma, then you are qualified for purposes of the job. You have to show that you were rejected for the position, and an employee outside of the protected class was selected for the position, or the employer continued to look for candidates. The short way of looking at a prima facie case is that a person is treated differently than another person in the same or similar circumstances. So that example I gave you a while ago of the 2 employees who come to work late, and I fire the man and I retain the woman, that's probably enough to get past this initial stage. I treated 2 similarly situated individuals differently. Now, I have defenses as an employer, but the burden is now going to shift to the employer, and I have to prove that I did not discriminate. And so the employer has a couple of defenses. The one that an employer will use 99% of the time is what we call a legitimate non-discriminatory reason, which is to say, yes, I treated them differently, but I had a good reason for doing so. So in our hypothetical of the retail establishment that fires the man and retains the woman, if I have records that show that the man has been late 10 times and the woman has never been late, then that is a legitimate non-discriminatory reason, LNDR. This is why HR has become so important in businesses today, because what is HR doing? They are establishing that the reasons for employment actions that take place are legitimate and not the result of illegal discrimination. Now, if I as an employer can prove LNDR, that is going to shift the burden back to the plaintiff. I have overcome the plaintiff's case. I have rebutted that case. The plaintiff, however, can then establish that LNDR, that it's not legitimate. It's actually what we call a pretext to hide unlawful discrimination. If I have, so going back to our situation, I fired the man, I kept the woman. If in fact it turns out that I had not disciplined women who had 20 tardies, or that there were emails that I had sent that said, I hate all male employees, I wish I could fire them all, then that would show that maybe the reason I took that action was not legitimate, and instead it was pretextual. So that is the LNDR defense, and again, 99% of the time, that's what an employer will reply to a claim of illegal discrimination. Now, there is another defense which you hear about a lot and which people tend to over-rely on, and that's called bona fide occupational qualification. We refer to this as BFOQ. Now, BFOQ is a doctrine that says I had to discriminate for my business, that I must discriminate. And so BFOQ is essentially legalized discrimination. And because it is legalized discrimination, legalized illegal discrimination, I should say, that is not available for claims of race and color. Race can never be a bona fide occupational qualification. Cannot be. The statute expressly forbids it. It is only for cases of sex, religion, and national origin. Again, it is legalized illegal discrimination, so this is why an employer rarely makes this defense. And in order to establish this defense, the employer must show that this preference goes to the very essence of its business. Meaning, if it cannot discriminate, it will go out of business. So that is disparate treatment and the two defenses to disparate treatment. Again, LNDR is going to be the preferred defense. Now we turn to disparate impact. Disparate impact exists where an employer has a policy that is neutral on its face, but has a negative impact upon a protected category. Imagine that I am putting out an ad for security guards. I have a security guard company. And in the ad, I say applicants must be at least 6 foot tall and weigh at least 200 pounds. Who's going to be excluded from that? Which group is going to be more likely to exclude? Now, I'm going to exclude men, for sure. But I am going to exclude a much greater percentage of women who don't meet those physical requirements. Therefore, this policy, although it's neutral on its face, I will accept an application from anyone who is 6'2" or over. Nevertheless, this policy is discriminatory because it has a disparate impact on a protected class. Now, as opposed to disparate treatment, disparate impact relates to groups and not individuals. So I was discriminated against because of my membership in a group. Claim, for instance, the security guard claim I just mentioned is not that I discriminate against this particular woman, but in fact my policy discriminates against many, many women. So groups and not individuals. Now, disparate impact regulates the use of what we call screening devices. A screening device can be any device that is used to eliminate people from further consideration. So something like a test or a physical requirements like height and weight requirements, or even an interview. Any screening device is regulated by the law of disparate impact. Now, what makes disparate impact so important for employers is that it provides for liability even in the case of unintentional discrimination. Even if the discrimination was negligent and not intentional, the employer can still be liable. If you as an employer utilize a rule, a neutral rule, but which has a negative impact, an adverse impact on a protected class, then you may be liable for discrimination, even though the rule was not put in place to discriminate. Now, there's several methods for establishing a prima facie case of disparate impact. Primarily, what is done is using statistics, which is to say this policy has had the result in hiring of a lower percentage of one type of protected class as opposed to another. Now, the standard, and this is a rule of thumb, this isn't law, this is simply a means of deciding whether there has been this adverse impact or not. We look to see, do protected employees fare at least 80% as well as the majority under the policy? This is sometimes called the 4/5 rule. And the 80% rule, or the 4/5 rule, states that the selection rate of the protected class should be at least 80% of the selection rate of the other class. Now, I've got another video that's going to set out a couple of these calculations to show you how we establish disparate impact. Now, after the plaintiff makes a prima facie case, after it shows that fewer than 80% of a protected class is being treated the same as other members of the class, then the burden shifts to the employer. The presumption goes into place, and again, the presumption is the employer discriminated. This policy, this screening device, has an adverse impact. So what can the employer do? Well, first of all, the employer can attack the plaintiff's statistics. These statistics that you've shown do not prove what it is that you are trying to prove. The employer can also rebut by saying that, yes, your statistics are right, but this screening device is a business necessity. The screening device is a business necessity. So business necessity is a defense to a claim of disparate impact. Now, what you would say is, the screening device is necessary for my business, meaning I must be able to discriminate on the basis of height and weight, for instance, for my security guard company. So I'll need to be able to prove that, which I may not be able to do. And I have to show that the screening device accurately measures for the quality that is sought. So I would have to say that individuals who are more than 6'2" and weigh more than 200 pounds make for better security officers than those who do not meet those standards. So this can be a very difficult thing to prove. Sometimes we think something should be true, but unless we have a way of establishing it, then it is not necessarily true. Now, there are other important anti-discrimination laws. There are federal anti-discrimination statutes that we haven't discussed, but which tend to be based on Title VII and follow the same rules as Title VII, starting with the ADEA, the Age Discrimination in Employment Act, that protects employees over the age of 40. The Americans with Disabilities Act protects employees with a physical or mental impairment that substantially limits a major life activity. That's the definition of disabled. And the Equal Pay Act. The Equal Pay Act prohibits unequal pay for equal work. So The law requires equal pay for equal work based on sex. Now, every state has its own version of Title VII, so there's not only a federal statute, but there are 51 state statutes that essentially mirror Title VII. In Oklahoma, the Oklahoma Anti-Discrimination Act mirrors Title VII. Thus, you can bring a claim for discrimination under either federal Title VII, the state OADA, or both. Now, why would you use both? In some states, state laws may have greater protection than federal laws. So, in conclusion, what do we learn in this lecture? Title VII protects against employment discrimination on the basis of membership in a protected class. There are two theories of discrimination: disparate treatment and disparate impact. And there are other state and federal anti-discrimination laws. I know that was a lot of material in a short period of time. If you have any questions, please reach out, and I will see you in the next video. Thanks.